Hello and welcome to this week's edition of Wednesday Wisdom. It looks like my screen is changing colors, so if it is on your end, and I'm going to try not to shake my desk, please forgive me. I don't know what that's about, but at any rate, my name is JB Hilliard, and these are short video snippets designed to answer questions you may have about estate planning or probate, or maybe other legal concerns that may be impacting your household. And I wanted to take a slight departure from our friend Sarah and her bakery to talk a little bit about something that has come up in recent conversation, in fact, with the meeting I had with the client this week, and in going through an appeals hearing for a probate case. It kind of culminated into this thought to share with you for this week's Wednesday Wisdom. And that's about your will, and particularly those of you who are do-it-yourselfers out there and have drafted or will draft your will yourself using a template or some online service, document drafting service, which is fine if that's what you want to do. But I want to talk about a provision that I always include in the wills that I draft, and that's called a no contest provision, where if you have any beneficiary listed in your will that would contest your will down the road, once you're gone and things have started to roll out with probating the will, if they contest it and lose, then they would forfeit their inheritance. And what this is designed to do, or the intent behind it, is to prevent or try to avoid litigation down the road. And this has come up recently for me. Like I said, I had an appeals case for one heir out of several who has just not been happy with the process or not happy with the results, and has kept filing motions, and we've been having to continue to defend the estate against his claims. And so that adds up a lot very quickly, especially when you're talking about over the course of several months, or in this particular case, several years. And I've had a couple other matters where the probate process was in year 2 or year 3, and there was infighting among the heirs or the beneficiaries. So one of the main intentions of this type of clause is to try to, as much as possible, prevent someone from wanting to litigate, just getting all out there all willy-nilly, just because they're mad about a situation, or they're not happy with how fast it's going or how slow it's going, or because so-and-so was put in charge and he doesn't know what he's doing, or she doesn't know what she's doing, and I don't like either one of them. To prevent that sort of thing from happening. Now, it doesn't prevent an heir, let's say, or a beneficiary from filing a suit or filing a motion or making a claim of wrongdoing and wanting to, let's say, remove the executor from that role because the executor is stealing from the estate, or mismanaging the process, or not being communicative with the other heirs or beneficiaries, or something where they're actually breaking a law, then that's a different story. But if it's just a lot of the pettiness and, for lack of a better, more legalistic term, the foolishness, then, this is a good provision to include. And even though a lot of people I come in contact with when we're on the estate planning side, they say, well, our family gets along fine, everyone gets along, there are no issues, I can't really foresee anybody acting out. Let me just tell you, people change when there's a death involved. People change when there's perceived money or, large valued assets involved. People change. And you never really know how they're going to act or react when it comes time to, take care of this type of business. So with that said, just be aware that this is something you could probably use, and it's better to have it and not need it than to need it and not have it. And with that said, as always, I thank you for watching, and we'll see you next time.